Hello, my name is Stephen Beam. I'm a consumer bankruptcy attorney certified by the American Board of Certification. Now, what is Chapter 13 bankruptcy? Chapter 13 bankruptcy is reorganization bankruptcy, or what I like to call partial repayment bankruptcy. This is the second most common type of bankruptcy that people file in the United States. In Chapter 13, one's debts are placed into a Chapter 13 plan that lasts from 3 to 5 years. Now, the duration of the plan depends on the level of one's income. The concept of the Chapter 13 plan is that one usually pays their mortgage creditors directly, car creditors directly, but when it comes to your unsecured creditors like medical creditors, credit card creditors, even student loans, one pays one monthly payment to a Chapter 13 bankruptcy trustee, who takes this one monthly payment and divides it up amongst one's creditors every month for either 36 months or 60 months. There is no interest or late fees or penalties in a Chapter 13 bankruptcy case, unlike outside of bankruptcy. All the payments that one makes in Chapter 13 bankruptcy goes to the principal that one owes on their medical debts, credit card debts, student loans. Now, there's a lot of things that one can do in Chapter 13 that they can't do in other kinds of bankruptcy. Namely, one can pay delinquent mortgage balances in one's Chapter 13 plan. So, if you file bankruptcy on December 1st and you're $10,000 delinquent with your mortgage payments, well, starting in January 1st, all your obligation is to make your regular monthly mortgage payment and make your Chapter 13 payment, and the Chapter 13 trustee will cure or pay off the pre-bankruptcy mortgage delinquency. With Chapter 13, there is no set amount of debt that one must have in order to file. Typically, people who file Chapter 13 bankruptcy have necessary income that's in excess of their regular necessary living expenses. Let's say your income is $5,000 a month, and let's say that your regular necessary living expenses, mortgage, food, car insurance, are $4,500. So that leaves a $500 income surplus. Now, outside Chapter 13 bankruptcy, that $500 doesn't go very far because this creditor wants $300 a month, this creditor wants $400 a month, this creditor wants $200 a month, and each creditor is charging interest and late fees and penalties, causing that debt to spiral up and metastasize even further. In Chapter 13, that interest, late fees, penalties do not exist. Your payments are contributed just to the particular principal of debt that you owe. Now, who can file for Chapter 13 bankruptcy relief? Well, there is no set amount of debt that one must have in order to file a Chapter 13 case. Typically, people who file for Chapter 13 bankruptcy have income, household income, that is in excess of the state average income for a household of their size. In other words, they fail the means test. Other circumstances that lead one to file Chapter 13 bankruptcy relief are their life circumstances, such as having a pre-bankruptcy mortgage delinquency or a car loan that is past due. In Chapter 13, you can do many interesting things. For instance, you can pay back pre-bankruptcy mortgage delinquency, you can pay tax debt in full, you can pay alimony delinquency or child support delinquency, or you can even do something known as cram down. What cram down is where you have a vehicle loan where you owe $30,000 on a particular vehicle, and let's say that vehicle is worth $20,000, and let's say the interest rate is 24%. Now, in Chapter 13 bankruptcy, you can cram down the debt down to the present value, $20,000 vehicle value. You can also cram down the interest from 24% to 6%. So there are many things that you can do in Chapter 13 bankruptcy that help people reorganize their finances into one monthly payment. That's the concept of Chapter 13 bankruptcy. You draft a Chapter 13 plan wherein you specify, I'm going to make my regular mortgage payments directly to my mortgage lender, and I'm going to make my regular car payment to my car lender, and then I have $500 or $300 or $100, I'm going to pay that to the Chapter 13 bankruptcy trustee, and then the trustee, pursuant to the terms of my Chapter 13 bankruptcy plan, is going to divide that up amongst my various creditors for either 3 to 5 years. Now, when that plan term of 3 to 5 years is concluded, maybe you've paid off 10% or 15% or 20% of the pre-existing debts that you owe. The concept of Chapter 13 bankruptcy is that when that term is over, whatever you've not paid is completely discharged or wiped away. How long does Chapter 13 bankruptcy stay on one's credit? Well, like with the Chapter 7, it varies, but in most cases, any bankruptcy will remain on your credit profile for 5 to 6 years. Now, in Chapter 13, that time period does not start when your Chapter 13 plan ends in 3 or 5 years. That time period starts the day after your case is filed. So a lot of people, when they exit bankruptcy in Chapter 13 in 3 or 5 years, they actually have fairly decent credit profiles because their credit has had 3 to 5 years to rehabilitate from the date that their case was filed. As you can see, Chapter 13 bankruptcy can be a complicated process. I would like to help you navigate through that process to determine if it's right for you and if it will benefit you. If you're interested in talking about Chapter 13 bankruptcy and see if it fits your life circumstances, please give me a call for a free consultation. I'd be happy to sit down and visit with you.